Hello everyone. Welcome back to our channel, U.S. Immigration News. We hope you're doing great. In this video, we're going to talk about Trump's proposal to eliminate chain migration, F1, F3, and F4 visas in danger, and Trump's new citizenship rule. Under the Trump administration, significant changes to family-based immigration were proposed, focusing on limiting chain migration. The administration targeted visa categories like F1, F3, and F4, arguing they contributed to excessive immigration. This push was part of a broader shift toward a merit-based system prioritizing skills over family ties. If you're interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. Trump's plan to end chain migration, F1, F3, F4 visas at risk. During the Trump administration, family-based immigration was one of the key points of contention in the broader discussion on immigration reform. One of the most significant changes proposed was a crackdown on what was often referred to as chain migration. The term, as used by the Trump administration, described the process where immigrants sponsored extended family members for U.S. visas, resulting in a cascade of green cards for relatives and their families. The administration argued that these policies led to an uncontrolled influx of immigrants, which they believe had negative social and economic implications. As part of this agenda, several family-based visa categories, specifically F1, F3, and F4, were at risk of being eliminated or severely restricted. F1 visa, unmarried sons and daughters of U.S. citizens. The F1 category allows U.S. citizens to sponsor their unmarried sons or daughters who are 21 years of age or older. This process, which can eventually lead to permanent residency and U.S. citizenship, was seen as a key part of family reunification. However, under the Trump administration's proposed reforms, this category came under heavy scrutiny due to its association with chain migration. Critics argued that the F1 visa could initiate a chain reaction of sponsorships. If a U.S. citizen successfully brought their adult child into the country, that child could later marry someone from their home country. In turn, the spouse could be sponsored for a green card, followed by other family members, such as parents or siblings, who could also immigrate. This was viewed as a potential loophole that allowed extended family members to join the U.S. population through a single, initial sponsorship. Although family reunification remains a central tenet of U.S. immigration policy, the Trump administration considered eliminating the F1 visa category, claiming that it contributed to chain migration. If such a proposal had been successful, it would have severely limited the ability of U.S. citizens to bring their adult children into the country, particularly those who are 21 or older. F3 visa, married children of U.S. citizens. The F3 visa applies to married children of U.S. citizens. If a U.S. citizen sponsors their married child, 21 or older, that child can immigrate to the U.S. with their spouse and children, thus bringing a significant number of people into the country at once. This has long been one of the largest categories for family-based immigration. The Trump administration's concerns over the F3 visa mirrored those associated with the F1 visa, namely, that it encouraged chain migration. If a married child and their family immigrated, the chain could extend further as the newly arrived immigrants sponsored their own family members. This was perceived as a threat to the limits on immigration and was seen as a catalyst for significant population increases without a corresponding focus on skills or employment. The administration sought to reduce the number of F3 visas, which would have meant a lower number of immigrants entering the U.S. through this route. In some cases, the proposal aimed to eliminate this category altogether, thus preventing the kind of large-scale family reunification that it promoted. This video was a central element of the merit-based immigration system that President Trump advocated for, which emphasized the value of skills and education over familial ties. F4 visa, siblings of U.S. citizens. Perhaps one of the most controversial and heavily targeted categories was the F4 visa, which covers siblings of U.S. citizens. This category was seen as a major source of chain migration, given the long waiting times for a visa to become available and the possibility of family reunification spreading to other relatives. Applicants often face wait times of 15 to 20 years, depending on their country of origin, but once an F4 visa was granted, the new immigrants could sponsor other family members. The Trump administration viewed the F4 visa as an example of extended family immigration that it sought to limit or eliminate. It was often cited as a loophole where one immigrant could eventually sponsor numerous relatives, contributing to a substantial increase in the number of green cards issued. The family member who immigrated might eventually be able to sponsor their own children, siblings, and parents, perpetuating a cycle of immigration that critics labeled chain migration. Eliminating the F4 visa was a major part of Trump's efforts to curtail family-based immigration and shift the focus to employment-based immigration. While the administration sought to restrict the number of family-based visas, it simultaneously worked to increase the number of visas available for individuals with specific skills or job offers in the U.S., arguing that this would benefit the economy. Shift to merit-based immigration. Under the Trump administration, the focus of immigration policy shifted toward a merit-based system, which would prioritize factors like education, employment, and specialized skills over family connections. The administration's proposed immigration reform bill, the Reforming American Immigration for Strong Employment Act, aimed to drastically reduce the number of family-based visa categories. The F1, F3, and F4 visa categories were seen as prime candidates for elimination or significant reduction. The rationale behind this shift was to reduce the number of immigrants entering the U.S. through family ties and instead prioritize those who could contribute economically through their skills and education. Proponents of the merit-based system argued that it would create a more robust economy and reduce the strain on social services, while opponents claimed it would harm families and reduce diversity within the U.S. Impact on immigration and family reunification. If the Trump administration's proposals had been fully implemented, the F1, F3, and F4 visa categories would likely have faced significant reductions or elimination. Such changes would have created even more significant backlogs in the immigration system, particularly for those seeking to reunite with family members. Immigrants who had long-term plans to reunite with their adult children, married children, or siblings could have faced even longer waits, or in some cases, have been entirely barred from sponsoring those family members. The Trump administration's focus on limiting family-based immigration would have fundamentally altered the nature of U.S. immigration policy. The emphasis on merit-based criteria might have shifted the immigration landscape toward professionals and highly skilled individuals, potentially changing the social fabric of the nation and its approach to family reunification. While the future of these visa categories remains uncertain, the discussions during the Trump years left a lasting impact on how family-based immigration is viewed and debated in the U.S. Donald Trump's new citizenship rule. Is your family at risk even with an H-1B or green card? H-1B visa new rule. This change has significant implications for Indian immigrants, particularly those stuck in the decades-long employment-based green card backlog. U.S. President Donald Trump has signed an executive order to end automatic citizenship for U.S.-born children of undocumented immigrants, setting the stage for a legal battle over the 14th Amendment. Starting in 30 days, federal agencies will no longer issue citizenship documents to such children, effectively challenging a constitutional guarantee upheld for over 150 years. Trump argued the 14th Amendment has been misinterpreted. The 14th Amendment has never been interpreted to universally grant citizenship to everyone born in the United States, he said. Under the new rule, children born to parents who are neither U.S. citizens nor lawful permanent residents will no longer be considered citizens at birth. This change has significant implications for Indian immigrants, particularly those stuck in the decades-long employment-based green card backlog. Many Indian families rely on birthright citizenship for their U.S.-born children to gain legal standing and eventually help their parents navigate immigration hurdles. Children born to parents on temporary work visas like H-1B or dependent visas like H-4 will now lose automatic citizenship. This creates new uncertainties for families who are already facing delays in securing permanent residency. For many, the ability of their U.S.-born children to sponsor them for a green card upon reaching adulthood was a critical part of their long-term immigration plans. One immigration lawyer explained, if both parents are in the U.S. on non-immigrant visas, their child will no longer be issued a U.S. passport under this executive order. It's a ripple effect that will disrupt lives, especially for families caught in long backlogs. For Indian couples on non-immigrant visas, the impact is immediate. Birthright citizenship often served as a safety net for children, giving families some stability as they waited for permanent residency. Now, families will need to reassess their immigration strategies and face the possibility of returning to India when their visas expire. Legal experts widely believe the order will face significant challenges in court. Greg Siskind, co-founder of immigration law firm Siskind Susser, called the order stunningly unconstitutional. He explained that the 14th Amendment's phrase, subject to the jurisdiction thereof, has consistently been interpreted to include nearly all individuals born on U.S. soil, except children of diplomats or enemy occupiers. The fight over Trump's executive order is likely to head to the Supreme Court, where the conservative-leaning bench will play a decisive role. For now, Indian families and millions of others await clarity on what this dramatic shift means for their futures. The Trump administration's proposed changes to family-based immigration sparked debate about balancing family reunification with economic priorities. As legal challenges unfold, the future of these reforms remains uncertain, with lasting implications for U.S. immigration policy. That is all for today in this video. What are your thoughts on this? Please let us know in the comment section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.
Hello everyone, welcome back to our channel US Immigration News. We hope you are doing great. In this video, we are going to talk about Trump's proposal to eliminate chain migration F1, F3 and F4 visas in danger. Under the Trump administration, family-based immigration policies, particularly those involving chain migration, were a focal point of proposed reform. The term chain migration referred to the process where immigrants could sponsor extended family members for US visas, which critics argue lead to uncontrolled immigration. The Trump administration sought to limit or eliminate certain family-based visa categories, specifically F1, F3 and F4 visas, as a part of a broader effort to reduce immigration through family ties. The F1 visa for unmarried children 21 or older of US citizens was under scrutiny because it could set off a chain of sponsorships. If an adult child immigrated, they could eventually sponsor their spouse and other family members, leading to additional immigration. The Trump administration considered eliminating this visa category, arguing it contributed to chain migration. Similarly, the F3 visa, which allows US citizens to sponsor their married children and their families, was seen as another pathway for large-scale family immigration. The administration sought to reduce the number of F3 visas, which were one of the largest family-based categories, to limit the number of immigrants entering through family connections rather than employment or skills. The F4 visa for siblings of US citizens was one of the most controversial visa categories targeted by the Trump administration. This category was criticized for enabling chain migration because once an individuals immigrated, they could sponsor additional relatives such as parents, children, and siblings. The Trump administration proposed reducing or eliminating the F4 visa as a part of its shift to a merit-based immigration system, which would prioritize skill and education over familial ties. This reform aimed to curb family-based immigration and focus on attracting immigrants who could contribute economically. Opponents of the merit-based system argued it would strengthen the economy, while critics feared it would reduce opportunities for family reunification and diminish the country's diversity. If implemented, this proposal could have caused longer waiting times for immigrants seeking to reunite with family members. Additionally, Trump signed an executive orders to end automatic citizenship for US-born children of undocumented immigrants, which affected children born to parents on temporary work visas like H-1B. This new rule created uncertainty for families, particularly Indian immigrants facing lengthy green card backlogs. Critics argue that this move could disrupt long-term immigration plans, and legal experts anticipated that the rule would face legal challenges, potentially reaching the Supreme Court.